Okay, the recording has started. Welcome to week 7 of our online lecture for CRW2601. Now, to avoid confusion, when we say week 7, we're talking about the 7th week on which we've been delivering online weekly lectures since the 28th of April 2021. In the first lecture, we combined study units 1 and 2 in one session. And then from then on, we continued sequentially with the online lectures for each study unit. So despite it being week 7, we are on study unit 8 of the study guide. So we are covering today the second half of criminal capacity. That would be mental illness and youth. So just for those who have recently joined us, those who struggled with registration, I welcome you now that you are back and you have access to the online lectures and all the material that is available on my UNISA. Just to remind you that there are recorded lectures of the previous study units in the previous weeks. You will find all of those under the announcements menu on the My UNISA portal. So please take your time to scroll as you go through each unit, to scroll down the announcements page to access every recorded lecture for each week and every slide that is provided with the accompanying lecture. With those house rules in place, let us get into the actual lecture. Just by way of recap, we have covered, as I said, since the 28th of April, it was study units 1 and 2, or chapters 1 and 2. Then from the beginning of May, we got into the Act requirement and omissions. On week 3, we covered definitional elements and causation. And for those of you who are still panicking about the assignments, I can freely inform you, given the tight schedules that you have, that the assignment is based on study unit 4. That is week 3 of the online lecture. So when you go to the announcements page, look for week 3 online lecture notes and recordings. You will find there the notes on study unit 4. You will find the recording for the purpose of enlightening your understanding of that unit. Please note that there has been an extension given on the 8th of June, which was yesterday communicated. Students were struggling to upload their assignments, and I understand that the system actually shut down at some point, even as early as 6 p.m. Please note that now you have been given an opportunity to submit up until Monday, the 14th of June. Please note that this extension only applies to assignment 1. It does not apply to assignment 2. So the due date for assignment 2, which is the 15th of June, is still applicable and must be complied with. Please ensure that you manage your time in such a way that you are able to submit both assignment 1 and assignment 2 by those due dates. So now coming to week 4, we began unlawfulness, and we covered the concept of unlawfulness and private defense. Afterwards, we covered in the following week, unlawfulness 2, where we covered necessity and other grounds of justification. Those were covered by my colleague, Professor Mollema. Then last week we began the concept of culpability. This is study unit 7. And we began by explaining that culpability comprises two components. It comprises criminal capacity and a fault requirement, either intention or negligence, depending on how the crime is defined. We also went further to explain the two legs of culpability, the two legs of criminal capacity. That is the ability to appreciate the wrongfulness of one's act and the ability to act in accordance with an appreciation of wrongfulness. Just to recap briefly, the criminal capacity deals with mental abilities or mental faculties that are presumed to exist upon every human being who is accused of a crime. It is presumed that they have the mental ability to appreciate right from wrong, or otherwise stated, the mental ability to appreciate the wrongfulness of their act or omission, and that they have the ability to the ability to act in accordance with an appreciation of wrongfulness. The two legs concerned, the first one is referred to as the cognitive leg, and the second one is referred to as, the first one is referred to as the cognitive leg of the test, and the second is referred to as the cognitive leg of the test. Cognitive being insight, understanding, cognitive being self-control. Then we covered towards the end of the guide the first of the three defenses that exclude criminal capacity. That defense is known as non-pathological criminal incapacity. Please revisit the online lecture for that section. But in brief, non-pathological criminal incapacity, just to distinguish it from pathological incapacity, is where X, at the time of committing the offense concerned, temporarily lacked either the ability to appreciate the wrongfulness of his conduct or the ability to act in accordance with such appreciation based on factors outside of mental illness. So those factors could either be provocation or emotional stress, it could be heightened anxiety, it could be intoxication, or just a complete emotional collapse. Those are factors that can impact one's mental faculties at the relevant time. And if it's not based on mental illness, it's referred to as non-pathological criminal incapacity. Now, the other two defenses are the ones that we are covering today. Those are mental illness and youth. Now, these are special defenses because for the first time, we are covering general principles that are regulated by legislation, not by the common law. So the defenses of mental illness is covered by Section 78 of the Criminal Procedure Act, whereas the defense of youth is covered under the Child Justice Act. So when considering the nature of these defenses, a court has to regulate itself and its conduct within what the statutes provide in this instance. Now let's get into, we are now on page, those of you who are following the study guide, we are on page 113 of your study guide, and we will begin at 115, talking about mental illness. The first thing that's important for you to note is that it was previously referred to as the defense of insanity. That concept has fallen away given modern psychiatry. We don't refer to it as insanity anymore. We refer to it as mental illness. It is regulated by the Criminal Procedure Act of 1977. And the definition of that is found under 8.2.2 in that gray block on page 115. Please make sure that you understand this definition because it is important. Now, let me explain the components of this definition so that you are well aware of what we are referring to here. Unlike the defense of criminal capacity or the legs of criminal capacity in itself, whereby we are looking at outside factors affecting the two legs that we spoke about previously. This time we are looking at the impact of a mental illness. If X is diagnosed as having a mental illness or a mental defect, what was the impact of that on any of those two legs of capacity? Either one is okay, and you will recognize that when we look at the actual definition. It says that a person who commits an act or makes an omission which constitutes an offense and who at the time of commission suffers from a mental illness or mental defect which makes him or her incapable of A, appreciating the wrongfulness of his or her act or omission, or B, of acting in accordance with an appreciation of the wrongfulness of their conduct, shall not be criminally responsible for such act or omission. Now notice firstly, there must be established a mental illness. So first and foremost, the step is that the court will have to establish that at the time of commission, X was suffering from a mental illness. Now, procedurally, what that would entail is that because the law starts from a presumption that everybody is presumed sane unless proved otherwise, whoever raises the issue of mental illness will have the burden of establishing that at that time the accused suffered from a recognized mental illness or a mental defect. And that will require the evidence of psychiatrists and psychologists. It is not a field that lawyers are comfortable in. They have to rely on psychiatrists to help them establish the existence of a mental illness or a mental defect. Now, if you are following the study guide, we are attempting to analyze the section 78.1 to tell you that there are two legs. There is a pathological leg or a biological leg, and there is the psychological leg. If you look at the diagram that's on page 116, you will recognize that the pathological leg has to impact one of the psychological legs represented by the two components of criminal capacity, any one of them, before we can say that X can rely on mental illness as a defense. So the mere existence or proof of a mental illness is not sufficient. Otherwise, the courts will depend exclusively on psychiatrists. So once a psychiatrist makes an assessment, let's say X is taken to Viscopies or to Sterkfontein to be mentally assessed, and the psychiatrists are required to come back with a report explaining that, do you believe that X at the time when he committed the conduct concerned was suffering from a known mental illness or defect? They will make their assessment and come back to the court and give a report explaining whether they have established whether X is diagnosed with having suffered a mental illness or some sort of mental defect. Then once that report comes before the court, they will also have to make an assessment as to whether, in their opinion, based on the facts and the evidence presented that led to their diagnosis, are they of the opinion that any of the two legs were affected by the mental illness that has been diagnosed. What then do we mean by mental illness? In the case of Mahlanzi, 1967, despite it being as old as 1967, the principles in that case still live today. So the first thing is that when we talk about a pathological illness, we are talking about a disease of the mind or a diseased mind. This does not mean that the mental illness must arise from the mind, because it is possible to have a mental or a diseased mind rise organically, either from the disintegration of the brain or the disintegration of arteries, disturbances of the mental faculties, either from schizophrenia or melancholia and other psychosis that are recognized by psychologists and psychiatrists. So the court is not too concerned about the origin of where that mental illness or mental defect comes from. That's the job of the psychiatrist. The courts are only concerned about the impact of that diagnosed mental illness upon the two legs at the time in question. And then mental illness can either be temporary or permanent. Remember that the key here, in fact, there's an interesting case that I read. It's the case of S versus von Zell, 1953, 3 SA 303A. What was interesting about that case, okay, let me make sure that I got the correct citation there. Oh, sorry. The case reference is S versus McBride. It's 1979 4 SA 313W. Now, the accused had killed his wife while suffering from endogenous depression. The expert medical evidence was that the accused was capable of appreciating the wrongfulness of his act, but that he was unable to act in accordance with such an appreciation. But subsequent to the murder of his wife and after treatment, the accused had recovered from his mental illness. So in other words, by the time the accused came back to court for his matter on appeal, he was mentally okay. And now the question that the court had to battle and wrestle with is whether it would be appropriate for them to still order that he be sent to a psychiatric ward or to a mental detention facility. So I'm highlighting that case just to demonstrate that a mental illness or a defect can also be temporary. It need not be a permanent condition. There are mental conditions that can be treated and whereby the accused can recover fully. So it does not have to be permanent. It can be temporary. Intoxication can also produce a known mental illness called delirium tremens. This is a situation whereby chronic abuse of alcohol and constant withdrawal as well creates a mental condition that is recognized as a mental illness. In that instance, if X suffered from that, then X can escape, can be found not criminally responsible. A word on the concept of mental defect. A mental defect is different from a mental illness in the sense that a mental defect is something that is identified from an early age. It could be something that the person could have been born with in terms of mental retardation. So for example, somebody who develops rather slowly in certain faculties, emotionally, mentally, and so on, could be suffering from a mental defect. Now, in those instances, mental defects are of a permanent nature, and they relate more to developmental realities. And one such situation is psychopaths. It has been diagnosed that psychopaths are people who are, let me just get the phrase correctly, they are people who are emotionally immature. A psychopath is somebody who is emotionally unstable, whose powers of inhibition, that means self-control, are relatively weak compared to someone else. Such persons are incapable of controlling their emotions. So a psychopath is somebody who can be said more or less to have some sort of a defect. But interestingly, the courts have held that despite such conditions, a psychopath can at the very least or at the very most be held to have diminished responsibility. But otherwise, a psychopath, we're not concerned, the courts have said, we are not concerned whether somebody can control their emotions. We are concerned whether somebody can control their conduct. So that's the most important differentiation that the courts have said. We are more concerned when looking at the defense of mental illness as to whether X is able to control himself or to act in accordance with an appreciation of wrongfulness at that time. We're not concerned about whether X is able to control his emotions. Now, as I said, there is the pathological leg, which is the mental illness, and then there is the psychological legs, which has the two legs of criminal capacity, which we introduced last week. Please note that for the defense of mental illness, it is not necessary that both of them be lacking. It only needs to be established whether the mental illness has affected either one of them. Now that is clear from the word or, which is between the A and the B. In other words, there must be a causal connection between the mental illness and the lack of mental faculties or mental abilities. The mental illness or mental defect has to have affected any one of the mental faculties concerned to result in lack of criminal capacity. Now, there's the interesting case of Kavin, which is explained on page 119 of your study guide. In this interesting case, X killed 3 people, that's his wife and 2 children, and attempted to kill a third one. He was going through financial difficulties, and he believed that by doing what he did, his family will be reunited in heaven with him. Now, going to that interesting case itself, the court diagnosed the following: severe reactive depression superimposed on a type of personality disorder displaying immature and unreflective behavior. Now, all 3 psychologists decided and held that that mental illness affected X's ability to act in accordance with an appreciation of wrongfulness. In other words, his mental illness affected the cognitive leg of the test. That's part B. Now, before the existence of Section 78, there was a a test called the irresistible impulse defense. In other words, if an accused were to say that because I had a mental illness and the mental illness affected my ability to control myself, the only way that the accused could escape or to succeed on that defense was if it was shown that he acted under irresistible impulse. Now, in the case of Kavin, the court went into an assessment of that to say that, well, in the case of Kavin, this guy went from bedroom to bedroom to carry out his evil intentions. He also took time to go down from the third floor of his house and go to the second floor and go to the first floor to go get a kitchen knife. So based on the slow and deliberate course of his conduct, he did not act under any irresistible impulse, because impulse implies something that just came in and just shocked you into action. But the court went further to say that Section 78(1)(b) is wide enough to cover the non-impulsive conduct of such an accused. And on the basis of that, the court held that the accused, by reason of mental illness, which made him incapable of acting in accordance with an appreciation of wrongfulness at the time of the commission of the offenses, was not criminally responsible in accordance with Section 78(1)(b). And accordingly, he was ordered to be detained in a mental hospital. That is the case of Kavin. In Kavin, we had a situation whereby the court recognized that someone can have a gradual disintegration of the personality through mental illness and therefore succeed through that. Please note, and I want to stress this, students often make the mistake of referring to Kavin as authority for non-pathological criminal incapacity. It is not the case. Kavin is an instance where the defense of mental illness succeeded. Now, coming to the defense of mental illness, as we said, the onus of proof rests upon the party who raises that defense. So, in other words, it's not only the defense that can raise mental illness, the state can also allege mental illness on behalf of the accused in that situation. So the Section 78 provides that the burden rests with the party who raises that defense at the time. And if mental illness is raised as a defense, there are a couple of verdicts that are referred to on page 119. Those verdicts are regulated by Section 78(6). X can either be admitted to and detained in an institution in order to be treated as an involuntary mental health care user. X can be released subject to conditions as the court considers appropriate, or X can be released unconditionally. And an example of unconditional release is where, for example, it is shown that as I referred to in the case of Van Zol, Van Zol had endogenous depression at the time when he killed his wife, but due to treatment over time, he was healed from that. And so in the case where X might have suffered from a mental illness and was treated and is mentally okay again, it might be in the interest of justice that X just be released unconditionally. There are other possible orders on page 120 of your guide there. If X is charged with murder, culpable homicide, rape, or any other serious violence or a crime relating to serious violence, which could be assault, GBH, or if the court considers it necessary in the public interest the court may direct that X be detained and in a psychiatric hospital or a prison until a judge in chambers, after receiving petition or affidavits from, it could be family members, it could be somebody, friends, it could be somebody who knows X well, to argue that X be possibly discharged. And then the judge in chambers will consider those submissions, and the judge has options as to what they will do afterwards. They could say that X remains a state patient. They could reclassify and deal with X according to the Mental Health User Act. X could be discharged unconditionally, or X could be discharged with conditions. All right, before getting to the youth question, let me get to diminished responsibility or capacity. Now, remember one thing. Remember the emphasis that I said that the courts are concerned only with whether the mental illness or defect affected any of the two legs of capacity. It is possible for somebody to have a mental illness or be diagnosed with a mental disease, but then it be discovered that it did not affect any of those two legs. And the classic example is, as I said, psychopaths. Psychopaths are recognized in psychiatry, so in other words, there are different degrees to psychosis and sorry, they call it psychopathy. There are different degrees to psychopathy that is recognized by psychiatrists. And it may be that despite the person having a recognized mental illness, recognized by psychiatrists, that person still was able to appreciate the wrongfulness of their conduct, and they were able to act in accordance with an appreciation of wrongfulness, even though they have a diminished ability to control themselves. So just because you have a diminished ability to exercise self-control does not necessarily mean that you can rely on the defense of mental illness. It only matters if the mental illness affected any of those two legs. So in that instance, what the court can do is that it will still hold you guilty of the crime concerned. In other words, you will not be able to rely on the defense of mental illness, but your sentence may be limited or decreased as a result of having diminished responsibility. Now, let's distinguish another concept here: mental abnormality at the time of the trial and mental abnormality at the time of the conduct. We have discussed so far only mental abnormality at the time of the conduct concerned. So if X is unable to stand trial because of mental illness, then the trial cannot continue. But that would be regulated by the other provisions of Criminal Procedure Act, and that is beyond the scope of this module. So just be aware of that. Now, moving right along to the defense of youth. As stated in my introduction, it is covered by the Child Justice Act 75 of 2008, Section 7 of which distinguishes between two categories of children, I would say, in this instance. Children under the age of 10 years and children who are 10 years or older but under the age of 14. Now, if a child commits an offense under the age of 10 years, Section 7.1 provides that such a child is presumed not to have criminal capacity and cannot be prosecuted for that offense. In other words, there's not even a chance for them to face prosecution of any sort. But if a child is 10 years or older, but under the age of 14 years at the time of committing the offense, there is a presumption, but the presumption concerned is rebuttable. So in the first instance, when the child is under the age of 10 years, it is said that the presumption of incapacity is irrebuttable. In other words, it cannot be rebutted by the state or the prosecution. But in the instance where the child is 10 years or older, but under the age of 14, the presumption is rebuttable. In other words, the state has an opportunity to prove that that child did have the two legs, did appreciate the wrongfulness of their conduct, and did act in accordance with such appreciation. And that proof must be beyond reasonable doubt in that instance. Otherwise, the state would have failed in its burden to establish criminal liability or capacity in that instance. All right, so that is the end of this unit. As I stated, the slides will be available. After this lecture, we will upload the slides and we will also upload the recording itself. And yeah, so if there are questions, I am available to assist and to handle those now. Okay, I see Nompulelelo, Rejoice. Nompumelelo, Rejoice, please unmute your mic.
I'm sorry, Jerry.
Yes,
Your responsibility.
Hello.
No, no.
Hello. Hello, Rejoice. Okay, I would like to request all students to just be patient because it does take time for some of your fellow students to just unmute their mics. So I would kindly request that we all respect each other. Don't listen to the question carefully because you just might benefit from the answer provided. Joanne, you can unmute your mic.
Hi, hi everyone. Yeah, I have two questions that's just been lingering, and I think this unit actually would help in regard to it. So my question is, when we look at a case relating to a so-called mistake, okay, I mistakenly shot my husband, for instance, can we consider a mistake as being negligent? Does it fall within the same category of prosecution, or would it fall in a separate aspect of prosecution?
All right. Thank you for the question, Joanne. The question of mistake deals with lack of intention. So we will cover that aspect when we deal with study unit 10 later on. So mistake is whereby X acts under a misapprehension now there are misapprehensions that are material and there are misapprehensions that are immaterial and would not exclude intention. But all of that you will understand more fully when we deal with study unit 9 and 10. So please be available for those units.
One last question.
Okay.
So I have gone through a little bit of study unit 9 and 10 in terms of reading and trying to understand and whatever. And that's my comparison with mistake and negligence. So in that example of me presumably shooting my husband as a mistake because it was dark and I didn't see him, right? So there is no intention there to want to cause harm to him. In a court case, a live situation, can I be charged for murder or attempted murder, although there was no intention? Because I still committed the crime.
Thank you for the question. You will be charged simply based on the fact that a death has occurred. So you will be charged with murder because somebody has died as a result of your conduct. So the question will just be whether the prosecution is able to establish all the elements of the crime in relation to your conduct and your state of mind. So based on what you are asserting, it seems that you would be, okay, depending what the surrounding circumstances are, perhaps you thought that the husband was an intruder, and you therefore thought you were defending yourself. That will be referred to as a mistake relating to a ground of justification, so, or a mistake relating to unlawfulness. In other words, your apprehension was that you thought you were acting lawfully in defending yourself, but the circumstances were such that, objectively speaking, there was no attack that was unlawful coming at you or that was imminent, that was taking place. So obviously on those reasons, you could not rely on private defense, but you could rely on putative private defense if the court on its assessment believes that your belief was reasonably held. Does that satisfy your answer?
It does. So basically, me as a person using oh no, but I made a mistake as a defense is not actually acceptable, because the court would obviously need to take in the elements of the crime and the reason behind it, as to why you reacted in such a manner, because I know that bodily action is also considered in terms of your state of mind, your body actions, circumstances, all that surrounding factors. You can't just say, okay, but I made a mistake. Now what? Am I right?
Well, obviously, any allegation has to be established. It has to be proved. So the court will have to look at the circumstances that caused you to act in that way, and then the court would have to place itself in your position and make inferences about what it would have thought of the environment concerned, whether it would have thought that 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 it was entitled to defend itself, and on the basis of that, the reasonableness or otherwise of your misapprehension or belief will be assessed. Is that, does that help?
Yes, it does. I have a bit more clarity on it, and I'm sure when we go through study unit 9 and 10, I would get a full understanding and grasp it a bit better.
Okay,
But for now, I'm sharp.
I'm happy. I'm happy I was able to help. I trust that it will become better as we go along. Please mute your mic. Thank you. Sune, can I ask you to unmute your mic?
Good afternoon, sir.
Afternoon.
So I just want to ask, I actually did it, I put it in the post as well with the discussions, but since I'm online now, I can quickly ask. I'm referring to the diminished responsibility or capacity. I just want to make sure I understand this correctly. If X suffers from a mental illness, but he is still able, or she is still able to appreciate the wrongfulness of the act, then she will not succeed on incapacity due to mental illness and may still be held liable. But if it is then found that for her it's more difficult than a normal person to act in accordance with her appreciation of right and wrong because of the mental illness, then a less harsh penalty may be issued. It may be considered. Is that correct?
Yes, that is correct. She will
Okay,
still
so
be.
is it the same as a mitigating factor? Can you say it's a mitigating factor?
Yes, I think it's fair to say that it can be considered as a mitigating factor that X was less able than a normal person to control and exercise self-control.
Okay, so it's not going to get you off the hook, but you might get a less severe sanction or
Yes,
punishment on that. All right.
correct. Yes.
Okay, thank you, sir.
All right, it's a pleasure. Please mute your mic. CZ. CZ, can you unmute your mic, please?
Good afternoon, everyone. I joined the class late because I had internet problems. But like I see we were discussing about mental illness and people doing crimes, people that are mentally ill doing crimes. So I wanted to ask about a real life scenario that I know of a person who is now mentally ill, but used to did something when used to be like, a person who was very corrupt, who was robbing people, and and then he had pending crimes, and then now he's mentally ill, and now I heard that he's in Portsmouth prison with other normal people, but he is mentally ill, and he is being actually prosecuted for those crimes that he did when he was still mentally well. Like in that case, like is that like lawful? Is it something right for the state to do to him? Now that considering the fact that he's now mentally ill and he's no longer living that life because of his mental state of mind, you see, but like now he's been actually in prison for like a month because of those crimes that he did in the past, which were pending, and now they actually arrested him for those crimes.
Okay, thank you for that question. I think that will fall under the decision of the parole board or the correctional services as to how that person should spend the rest of their sentence. So what would happen is that either the family or concerned members of the community or relatives can actually make a petition for that person's circumstances to be reconsidered. If the conditions do not suit that person staying and continuing in prison where they are, then they can be sent rather to a psychiatric ward. But that will depend on the application that is made to a judge in chambers, and the judge would have to assess that and make a decision on that aspect.
Okay, so it is a right thing to keep him where it is, and then they just have to wait on the judge to decide whether to take him to a place where there's other psychiatric prisoners as well. Because like he's not with normal people.
I think for the safety of those normal people and for his own personal safety, because obviously if people can take advantage of him, so I would think that in that case the family should probably apply to a judge in chambers or make a petition for him to be transferred to a different facility.
Okay, thank you, Mr. Ramosa. Yeah.
Okay. Okay, all right. Kumbu.
Thank you, Mr. Ramosa. Can you hear me?
I can hear you clearly.
Okay, so I'm just following up on Sune's question on mental illness. What I wanted to just find out, because the only example that I see where it says you'll be convicted of lesser crime, so to speak. But now I wanted to find out, the only example that I see on the study guide is when a person is convicted and then they are now completely normal again, so they are now convicted on a lesser crime. So I'm trying to find out what kind of an example would that be for a person to be convicted of a lesser crime when they were charged, when they lack capacity because of mental illness. I don't know if you understand me.
Okay, let me try and make sure that I understood you correctly. At the time when they committed the crime, was it established that the mental illness affected
Yes.
the legs?
Yes. So they had mental illness, and then now they are convicted of a lesser crime. But now I need to find out what kind of an example would be the best example for a person who's convicted of a lesser crime, rather than being the fact that they were normal again. That's why now you are getting a lesser. I don't know if you understand me. I'm trying to see of another example that would be that you are no longer going to be, you will be convicted of a lesser crime.
Okay, let me help you there. If the person had mental illness and it affected one of those legs, the court would find him not guilty based on the defense of mental illness. So it's not a conviction. That's the first thing I want to make clear. It's not
Okay.
a conviction. That person is not mentally okay and will have to be sent to a psychiatric ward.
Oh, okay.
Yeah, so it's not, there is no way that a mentally ill person can be liable for a crime.
Oh, okay. Okay. So there's no conviction.
It's not a conviction, yes.
Oh, okay. 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 That's fine. Okay. I don't think.
Does that clarify you?
It's just that I saw an example on the study guide where it says if they are completely normal again, mentally completely normal again, that means that they committed a crime when they were mentally ill, but when they went to court proceedings, they were now normal again. So
Yeah.
now.
Okay, yes, let me get to that. Of course, because they are normal again, the question will now be, what does the court actually order? What kind of order does the court actually give? And in that instance, it can release the person unconditionally. Because there would be no point, in sending that person to a psychiatric ward.
Yeah. But then at the time of the crime, they were not they did not have criminal capacity.
Yes.
So they will be released unconditionally.
Yes.
Oh, okay. No, I understand. Thank you, Mr. Ramosa. Thank you so much.
It's a pleasure. Please mute your mic.
Okay, we'll do so.
For everyone who's writing comments or questions under the chat or the conversation link, I will make time to answer you. Please be patient with that. I'm going now to Bransby. Bransby Sheba, can you unmute your mic, please? Hello, Bransby. Okay, while we wait for Bransby to unmute their mic, I'll take I believe it's Mrs. Zeng. Is it Mrs. Zeng or Mr. Zeng? Can you unmute your mic, please?
Yes, Mr. Ramosa. Good afternoon. This is Zeng.
It's Mrs. Zeng. Okay, thank you, Mrs. Zeng.
Yes, initially I have a question I want to ask. It's basically refer to page 118 study guide.
Which page?
118.
Okay.
I talk about the last paragraph. So for me to understand the Kevin's case, because you mentioned the Kevin's case, we need to remember it's actually an example of defense of mental illness. It's not the example of defense of non-pathological, criminal incapacity.
Yes, yes, yes.
So I'm just linked to what you are explaining. I'm just trying to make sure my understanding is correct. The non-pathological criminal incapacity, the case referred in the study guide, basically it's Eddie's case. The Eddie's case, if my understanding of the last paragraph is mentioned about, it's basically talking about like irresistible impulse or provocation, right?
Okay, yes.
And that is defined because that is not recognized by the court, because as per the court, they're still thinking the person actually is still able to appreciate right and wrong. That is the reason, basically the reason, okay, the defense is not a success. But in the Kevin's case, it's talking about a gradual process of the disintegration of personality. So basically, they extended the mental illness to this kind of how you see symptom. Am I right?
Okay, let me make sure that I understand your question. You are seeking to make a distinction between NPCI, non-pathological criminal capacity, and the Kevin case in terms of the mental illness. Now, in Eddie, and in all other cases whereby we have non-pathological criminal incapacity, the incapacity is not as a result of a recognized psychological or mental illness or defect. So the incapacity does not arise because of a recognized, a known mental illness that is accepted by psychiatrists. The incapacity arises as a result of intoxication or other forms that are external from the accused mind, but affected his or her mental capacity or mental faculties, the two legs, at the time when he or she committed the crime. That is non-pathological criminal capacity. Now, what happened in Kevin is that Kevin was sent for psychiatric evaluation, and 3 psychiatrists diagnosed him as having severe reactive depression that affected his personality. So over time, he had a disintegration of his personality, which was recognized as a mental illness by all 3 psychiatrists. And on that basis, he was found not guilty as a result of mental illness, because it was discovered, or it was established, that the mental illness affected his ability to control himself.
Thank you, Mr. Ramasa. I understand this now. Can I ask you one more question? I mean, really relates to this.
Okay, go for it.
I read one case regarding Anita Ferreira, right? Anita Ferreira. This lady is actually I can't remember. Is married old man, or maybe taken by the old man. He was undergo repeatedly domestic violence.
Yes, got it.
He was I think he was locked by this person in the room for some years, and forbidden her to speaking to any other man, and it keep abuse her and beating her.
Yes.
And this girl was something like abandoned by the mother, at a young age, and she has no family support, and is actually hopeless, okay, in this situation. So in the end of the day, okay, she cannot, stand for it anymore. So she how can I say, walked out, with some workers and basically killed this man who abused her. And in the judgment, okay, and I think she has get mitigation, factor. It relates to the talking about, okay, this is where, I try to understand. We talk about she's also undergo, a gradual process of disintegration of the personality. So basically what I want to ask is whether, like mental illness, this definition has been extended, to the situation where the person, like for Anita's case, because he's undergo, for years, like abuse. So somewhere this personality has been gradually disintegrated. They can raise like this defense, for her, the mother case.
It's a very good question that you're asking, Mrs. Zhang. Remember when we covered the issue of private defense and we spoke about the Engelbrecht case and the concept of battered woman syndrome. In that case, it was not accepted as a defense excluding unlawfulness. In other words, Engelbrecht could not rely on private defense despite raising battered woman syndrome. I must also say that the field of psychiatry is an ever-evolving field. And I said at the time that it may happen in the not too distant future that psychiatrists may recognize further instances of mental abnormality or conditions that affect the mind to the point of disintegrating the ability of somebody to be able to control themselves, or disintegrating the ability of somebody's ability to distinguish between what's right and what's wrong. And I imagine that at some point in the future, that may just arise to be a scenario that is recognized as a mental illness. But that will have to be something that is moved by psychiatrists.
Okay, thank you, Mr. Ramosa. I think I sorted it. Thank
Okay.
you.
Can you mute your mic, please, Ms. Zhang? Thandeka Sindani.
Hello everyone. I have it's a quick one in terms of witchcraft. I know we just covered mental illness, but what the courts made way or to have to be open to the idea of witchcraft.
Thandeka, I just want to thank you so much for asking that interesting question. Can I explain to you what the facts of the Mahlanzi case were actually? The facts of the Mahlanzi case read as follows. During the night, the accused, a devoted mother, took off her clothing and placed it on a fire. She then placed her baby daughter, aged 6, and her son on the fire. The accused stood at the door of the kitchen to prevent the children from escaping. The baby was burned to death, but the other child escaped with burns. A psychiatrist who examined her reported that she was laughing and generally very rowdy. Her mood and behavior was out of line with the injuries sustained by her children. She could not give an account of herself or her behavior. She was disorientated and she had no insight into her condition. The psychiatrist diagnosed her to be in a state of hysterical dissociation. She was charged with murder, but found to be insane and thus not guilty. So in other words, to answer you shortly, that any African person or anyone who believes in witchcraft would probably deduce that those facts are just simply witchcraft. But witchcraft in and of itself is not a recognized mental illness, by the way. So remember the issue here is that the psychiatrist would have to identify that there was a recognized mental illness, and that mental illness affected one of the legs of criminal capacity.
Oh, okay. So witchcraft is not a recognized legal ground at all.
It would not be under the circumstances. You can't, I don't think you can come to court and claim witchcraft and say that is a mental illness.
Okay, but do you think maybe in future, in terms of developing customary law, maybe they could make way for that?
You see, I think the ultimate issue just for I don't want to delve into the realm of psychiatry because I'm not qualified in that area. So psychiatry would have to answer the question of whether they can recognize it under their discipline.
Oh.
But the law is only concerned with asking itself whether the mental condition was such that he can be held criminally responsible.
Okay, understood, sir. Thank you so much.
Thank you for the very brilliant question, though.
Thank you, sir.
Please mute your mic.
Sure.
Lituma Bosaleti, you can unmute your mic.
Yes, good afternoon, Mr. Ramos and everyone. Yes, my question relates to goes to the lady I think who asked earlier about is it one of the relative committed crime when we're still mentally insane, while we're still fine, but however then he was charged for those crimes and now he's in jail with people who are sane. However, my question is that I know we just explained earlier on that if you are insane, you're mentally incapable, you cannot stand trial in court. Now, question is that how did he stand trial for those crimes that he committed when he was still sane, but because now he's insane? So how did he stand trial and be charged with that? It's where I'm confused. Thank you.
Okay, I would assume that obviously when he stood trial, it was determined that he was mentally sane. He was able to understand the proceedings in question and understood what was happening around him. So if that's the case, then he is fit for trial.
Thank you, I'm answered.
Okay. All right, please mute your mic. Thank you. Christian Zungu.
Good afternoon, all.
Continue.
Yes, Mr. Ramos. I just need to find out something. A woman poisoned her 3 children due to misunderstanding or argument with the father of those children, and apparently all those children they were deceased, and she ended up in jail. Can she rely on one of those 2 legs?
So you say the woman poisoned her 3 children, né?
Yes, yes.
And they died.
And they died, yeah. And she did it because of stress and depression as well.
Okay. Well, yes. If that is indeed an allegation that is raised, it sounds very similar to the Coven case. there would have to be a psychiatric evaluation of the woman at the time of the trial, and a determination made by psychiatrist as to her mental, was she suffering from a disease of the mind that is recognized by psychiatry. And if that is determined to be so, as happened in Kavin, whereby there was diagnosed to have a severe reactive depression that affected the personality to the point of causing a disintegration of the personality, then yes, she could rely on mental illness.
Okay, thank you, sir.
Okay, thank you.
Thank you. Sharp.
Sharp, please mute your mic. Menzi Tulane, you can unmute your mic.
Good afternoon, Mr. Ramosa and everyone.
Go ahead.
Good afternoon, Mr. Ramosa. Okay. My question is based on the lucid intervallum maxim, which is like the lucid interval.
Yes.
In a situation, suppose the offender or a person commits an offense at that moment, would that person still be held liable for that criminal offense, or we assumed that he's maybe mentally incapable of committing the offense?
Thank you for the question. If during the commission of the offense,
Yes.
that person was mentally capable of appreciating right from wrong and acting accordingly, then that person had criminal capacity. So irrespective of whether before then he was mentally ill or after then he was mentally ill, if at the time when the crime was committed he had criminal capacity, he would be treated like any other offender.
Okay, then how will the court be able to ascertain that? Because I think it's a bit tricky. How would the court be able to ascertain that? Or maybe they'll have to engage like the persons who come from the mental fraternity.
Yes, obviously that will come from the evidence of the psychiatrists.
Okay.
Because they will obviously have to explain to the court what the mental condition that this person suffers from is. They will have to also explain to the court why is it that this mental condition comes and goes, if that is the case. And they will have to make the court at least understand how this mental condition operates. And then the court will then have to make an assessment based on that to say that, okay, it seems like this is a treatable mental illness. For example, in the case of Fonzel, as I spoke to you, the accused was diagnosed as having endogenous depression. And apparently that sort of depression is treatable and was treated. And at the time when the accused came back to court, the accused was sane and fine. So that is a demonstration that there are probably mental conditions that come and go in intervals, and they come, and maybe they are triggered by other physiological conditions or come in an organic situation or triggers of any sort. So in that instance, the court will then have to say, okay, this is treatable, but evidently at the time when this person committed the conduct, he was aware of what he was doing and he could control himself. So he'll be guilty.
Okay. Okay. Thank you so much. Thank you so much, sir. Thank you so much.
Okay. Okay. Pleasure. Pleasure. Please mute your mic. Okay. Snare Boy, can you unmute your mic? Hello, Snare Boy. Can you unmute your mic, please? All right, while we're waiting for Sneh, let me take the last hand that oh, okay. Sneh?
Good afternoon, sir. Good afternoon, sir, and to everyone.
Oh, thank you. Thank you, Sneh. Go ahead.
My question is, I have a follow-up question from a question that was asked earlier. From a person that was committed a crime while he was mentally ill. Now, at the time of the trial, he is mentally stable. Then you said that person will be discharged unconditionally. Then what I want to know is that how is the court going to prove that the person was mentally ill at that time he committed the crime?
Thank you, Sneh, for the question. As I answered the previous students who asked the question about the lucid interval, the court would have to understand from the evidence of the psychiatrist what is the nature of the mental illness or the mental disease concerned. The court would have to make an assessment as to whether it's a treatable mental disease. And if it is treatable and enables somebody to recover, then the evidence will speak for itself as far as what the court needs to do. Are you answered?
Yes, thanks a lot.
Okay, please mute your mic. I'll take the final question or the final hand that I see. It is that of Alice Rasijamatole.
Thank you, sir.
Okay.
My head. Yes, my question was on the children, the age restrictions that you've said that a 10-year-old or less cannot be charged. So we've had incidences where a child is a minor, committed a crime, and then they would say that they will wait for the child to reach a major stage, then they can resume their trial. Or can you clarify for me how the law was applied around that?
Okay, I'll be honest, Alice. I am unaware of such a case because if somebody under the age of 10 years commits a crime, at that time that person does not have criminal capacity and cannot be prosecuted. So the prosecution cannot say that it waits then for the child to be a major and then only charge them afterwards. That is nonsensical.
Oh, okay. Maybe I've missed the years wrong. But for a 15-year-old, you said can be charged, ne?
Yeah, I said between the ages of 10 and 14,
Yes.
if such person says that they didn't have capacity, the prosecution has an opportunity to rebut that presumption. So despite the presence of a presumption that they lacked capacity, the prosecution can lead evidence to demonstrate that this person, despite maybe being 14 or 13, this person, their mental faculties and abilities had developed to such an extent that this person is able to distinguish between what's right and what's wrong, and this person is able to control themselves.
Okay, all right. Thank you for that. Thanks.
Okay, let me try and move to some of the chats that are existing here. All right. Can I just ask for your patience as I go through some of them? I may not go through all of them in the course of this period because our time is almost up. But let me just handle a few. Comfort says, Mr. Ramusa, last week's recording wasn't shared. So when will it possibly be available on my UNISA? Comfort, last week's recording was shared. I I do note that I did receive queries about people being unable to access the link. If that is your experience, then I would urge you to send me an email communicating such. But otherwise, the current link you should be able to access. And that would apply also to any of the other students. Please, if you have queries about accessing the links, please send us an email or at least post it on the discussion forum on my UNISA. I have managed to help a few students there by actually reposting the link to last week's lecture. All right. Also seeing Kosana saying the same thing. Okay, please note that when you access the recordings, the audio may be delayed in coming through. So I would request that you just be patient about waiting for the audio to come through. But if you are unable generally to actually open that link, then please post it on my UNISA. I will share that link on that platform. All right, I'm still here, but I think most of the comments are comments that demonstrate that students are engaging what I've been saying or talking about. But please be reminded that you have the discussion forum platform to post any questions there. For example, many of you, obviously, because of late registration, are obviously behind in terms of going back and starting the units and getting into them. As you go along those, please feel free to post your questions under the discussion forum in the relevant unit or link created in the unit there, or send us an email and we will answer you. Please do not struggle on your own. Do not try and do it on your own. If you're overwhelmed, communicate, reach out to us. We are available. We will respond. Okay, Tabani Absalom, I've got your hand there, but I'll come back to you once I've looked at some of the text comments right now. Okay, Sunay, thank you. I have responded to your particular question. Jay Parsons, if someone is charged with murder but person was mentally ill, can he or she be convicted of a lesser crime or no crime at all? The answer is that person will not be convicted of any crime at all due to mental illness, and will be, generally speaking, ordered by the court to go to a psychiatric institution. Annalisa says, in a case where you mistakenly killed your partner because you probably thought he was an intruder, it's a mistake, yes, fine. But how many years of jail time would I have to face? And will I be trialed the same way as any other normal murder case? Or will my mental state or mistake in this regard be taken into consideration? And if mental health was seen as cause of the action, what happens then? Should I receive treatment? And what if I'm no longer mentally ill? Will I then resume trial of the murder and jail time? All right, it's a very convoluted question. I'll try to break it in parts. Please note that the defense of mistake is a defense excluding intention. It has no relevance to criminal capacity. So remember, when I made the distinction between a mistake whereby you thought something was happening, you thought you were being attacked, but in reality you were not, but you acted, or you believed that you were acting lawfully. That is a defense excluding intention. Please distinguish that from the concept of saying that X lacked the mental ability to appreciate right from wrong. Those two are different. That cognitive leg of capacity about appreciating right from wrong, it relates to presumed mental abilities. It does not relate to awareness. All right. Miranda, you asked a question about demonic possession. Which leg will this fall under? As I answered your earlier colleague about witchcraft, demonic possession would not necessarily be something that psychiatrists will say, you know, is a mental illness or defect. But you know, as I said, I don't want to venture into the realm of psychiatry. I think I might be presumptuous. But for now, what the court and what lawyers matter or care about is whether that inability to exercise capacity affected any of the legs, whether that mental illness affected any of the legs. Okay, for the sake of time and for everybody who is with us, let me firstly thank everyone for being part of the lecture. I will respond to the questions on the chat by writing and responding individually to them. But for now, let me take the question of Tabane Absalom Mazibuku as the last question on this matter. Tabani, can you please unmute your mic and ask your question?
Afternoon, Prof.
Afternoon.
I got left out on the ages between 10 and less than 14, where we said if the state does not follow up on criminal capacity, a child can prove. Suppose there are further charges and further investigations, and at the time of sentencing, the child is now 18. What happens?
The consideration will always be what was the condition or the state of that child at the time when the crime was committed. So in other words, what I'm saying is that the consideration is always about whether at the time when the crime was committed, there was both unlawful act and culpability, including criminal capacity.
Answered. It answers me. Now, which means the key is at the time.
At the time, yes.
Thank you very much.
Okay, thank you very much. The lectures, the weekly lectures are every Wednesday from 3 o'clock, and we push until 4:30. Next week it will continue that way. I've seen a couple of people getting confused when the announcement is posted. Remember that it's every Wednesday from 3 and up until 4:30. So next week we will cover study unit 9. We'll introduce the topic of intention now that we are complete and has finished criminal capacity. So I look forward to your interactive participation. I want to repeat again, if you are struggling with the links, which will be posted after this lecture, you please send an email or post your query on the discussion forum. We will post that link to make sure that everybody has access to it. Just a reminder that your due date for assignment 1 is next week, the 14th. Please don't wait until the last minute to do that. Those who have submitted, please don't try to resubmit. We beg of you, because we are already in the process of marking. It will really be a duplication and will give us problems. So we would encourage those that have submitted not to attempt a resubmission. Thank you very much for attending the lecture, and may you enjoy your day.
Thank you. Bye.